What is the difference? Earnest money is generally paid at the time of conclusion of the oral contract to give a confidence that the purchaser is willing to go ahead with the contract. That is what is called earnest money. So it represents a guarantee that the contract will be fulfilled, it will not be violated. So in all earnestness, the advance is paid. That is earnest amount. If the contract fails on account of the person, the purchaser, the vendee, then the earnest money can be forfeited. The earnest money can be forfeited, but not the advance. Advance is different from earnest money. This difference is pointed out by the Supreme Court in DDA versus Giristapana Cooperative Group Housing Society. Giristapana Cooperative Housing Society, DDA versus Cooperative Society, AR 1995 Supreme Court, page 1176. So these are the sometimes crucial terms in a contract. Readiness and willingness, which is also referred to in the section 16. So that is how we have to read section 10 along with sections 11 to as whenever it is a trust, otherwise along with sections 14 and 16. So we have to read these three provisions in juxtaposition. Then only we will understand whether a contract before us is enforceable or not. When a contract before us is enforceable or not. Earlier, under the old regime, the specific relief is a completely discretionary relief. If the court felt that compensation is adequate relief, the courts used to deny specific performance and used to grant compensation. But that section 20, which in detail dealt with the exercise of discretion, is now completely absent in the enactment. In its place, substituted performance section is introduced. So there is no discretion now. Now it is a statutory remedy. When specific performance, the contract is established, the court has no alternative but to grant a decree. It is mandatory. It is mandatory. Section 21 deals with, in this connection, after 20, power of the court to award compensation. Earlier, this section said specific performance can be granted under the old regime either in addition to or in substitution of. So exercising this power of discretion under 21, courts used to grant both specific performance and compensation or only compensation, but not both. But these words are removed under the new section 21. The discretion is removed. Now the only words appearing in the section are in addition to. In addition to, not in substitution of. This section is intended to promote specific performance, not to deny specific performance, but to promote specific performance. Section 20, old regime, is a very, very big section. old regime, is a very, very big section. The entire section is deleted. Now we have no discretion. So what are the situations which are retained after the amendment? Let us see. Let us recapitulate. What are the situations which are retained in the enactment, new enactment? Performance of a continuous duty which court cannot supervise, that cannot be enforced. That is B in the new section 14, that is D in the old section. So it is retained. Performance so dependent on personal qualification of parties that the court cannot enforce material terms. It is C in the new enactment and middle part of old B. So middle part of old B is only retained as new C. Contract is determinable by nature. Old Act D, Old Act C, New Act D, retained. What are the situations which are removed by the amendment? Let us also see them. Now we have seen what are retained. So what are the contracts not enforced, which are under the old section, which are now enforceable? Contract for performance of which compensation was adequate relief, it is removed. So even when adequate relief of compensation is there, we can enforce a contract. We cannot grant compensation. It is mandatory to enforce specific performance. Contract which ran into minute details, it was removed. So if contract is running into minute details also, now we can enforce it. Right. These are the points which are retained and which are removed. Under section 10, because sometimes we need a Supreme Court decision for emphasis. Whether the discretion is taken away or the discretion is still there, we may get a doubt. So the Supreme Court clarified in Santoshamma's case, 2020 INSC 566. Santoshamma versus Sarala, para 70. After amendment with effect from 1/10/2018, section 10 of the Specific Relief Act provides, specific performance of any contract may in discretion of the court be enforced, have been substituted with the words, specific performance of contract shall be enforced. The court is now obliged to enforce the specific performance of a contract subject to the provisions of subsection 211, section 14 and section 16 of this Specific Relief Act new. So that is how now the discretion of the court is fully taken away, and the only remedy we can grant when once the contract is established is enforce the contract. Enforce the contract. No compensation. You may, in addition to specific performance, award compensation, but not in substitution of. Specific performance. Right. These are the main amendments of the enactment. Then the next aspect is whether these amendments are prospective or retrospective. Whether all these amendments are prospective or retrospective. Then two questions arise before us. The agreement, say for example, agreement of sale, which is a contract, is prior to the amendment. Whether the new act applies to the contract which was entered prior to the amendment. The next question is, the suit is instituted before the amendment. The suit is instituted before the amendment. It may be a oral agreement, or there may be a written agreement also, contract reduced into writing. Which are the crucial dates? Which are the crucial dates? In Katta Sujata's case, the Supreme Court held that it is prospective. Why? Because it is making substantive changes. Any change in the substantive law will always be prospective. That is the broad rule of interpretation. That is the broad rule of interpretation. Well, in this Katta Sujata Reddy's case, the Supreme Court held that these amendments are prospective. They will not apply to the transactions prior to the amendments. But that is not the end of the matter. The same case, a review petition was filed. In the same case, before the Supreme Court, a review petition was filed. While not specifically holding that the amended provisions would govern the suits instituted prior to 2018 amendment, the review court proceeded to assume that the grant of specific performance continued to be discretionary to a suit instituted before the date of amendment. So instead of the transaction, the court held if the suit is instituted before the amendment, it is discretionary. Supposing the agreement is prior to the amendment, but the suit is instituted afterwards, then the amendment would apply. That is the intendment of the review judgment. But again, that is not the end of the matter. The same question came before the Supreme Court in an anomalized case. 2025 INSC 1267. 2025 INSC 1267. The Supreme Court referred to Katta Sujata Reddy's case, the review judgment in the same case, and noted as follows. Rather, in the review, this court proceeded to decide the matter by assuming that the grant of specific performance continued to be discretionary to a suit instituted before the date of amendment. So the Supreme Court is taking note of the review judgment. If the suit is instituted prior to the amendment and not after the amendment, then the discretionary relief can be granted. The discretion continues. We will proceed as if Section 20 is on the statute book. There is no amendment to Section 21. We will proceed on that line. But then in anomalized case, having noted what is stated in the review judgment, the Supreme Court went on to say like this. Besides the above, the judgment impugned in this appeal was passed on 2/2/18, that is before the amendment came into effect. The Supreme Court one step went ahead with one more step. The matter is already disposed of because the matter is before the Supreme Court by the primary court. The date of judgment was 2/2/18, that is prior to amendment. So therefore, the court proceeded in this case that the law existed on the date of judgment, that is the old law we will apply. So the situation now is in a quandary. The law is, I think, in my humble view, yet to be settled. These are the three views successively expressed by the Supreme Court. Different interpretations are being given by the jurists by saying that the law is prospective. But we don't know whether the law is retroactive or prospective in view of the observations, findings, ratio in the anomalized case. referring to the two views in Katta Sujata Reddy original decision and in the review decision. Any doubt? Now let us go to preventive relief. What is preventive relief? What is preventive relief? Injunctions. Injunctions. Both are restraining somebody from interfering with possession of a person is a preventive relief. Don't interfere. You are preventing him. Mandatory injunction is also in a way a preventive relief. Somebody encroached a portion of the site of the plaintiff and constructed a staircase. He seeks a mandatory injunction. You are preventing him in continuing the staircase by granting a relief of mandatory injunction. But be careful as youngsters, when such suit is filed, don't be satisfied by merely asking mandatory injunction. Because even if the steps are removed, the defendant remains in possession of that property. You must simultaneously seek recovery of possession of the property which is occupied for construction of the staircase. If you simply seek mandatory injunction, the property remains with the defendant. Possession of the property is not asked for. So you have to be very, very careful when you are drafting a suit like that. In perpetual injunction suits, we know the landmark judgment is Anatula Sudhakar's case. When a perpetual injunction suit can be filed, if a cloud is cast on your title, whether there arises a necessity to file a suit for declaration of title as well as consequential perpetual injunction, these are all questions of fact. Depending upon questions of facts of each case, you have to frame the suit and the relief. Supposing it is a moonshine denial of title, moonshine denial, merely because there is a denial, you need not seek declaration in some cases. It's a denial for the sake of denial, with no semblance of title, no document, not even a tax receipt at any point of time, merely because the plaintiff says he is in possession and is seeking an injunction, the defendant sets up a plea, the plaintiff was never in possession. So this is a preventive relief of perpetual injunction. Anatula Sudhakar's case, which helps all the youngsters how to frame the suits. It's a landmark judgment. I request all of you to read at your leisure the entire judgment. AIR 2008 Supreme Court 2033. Anatula Sudhakar. Wherein, with illustrations, the Supreme Court explained as to when a suit for injunction perpetual in simple sitter can be filed, when a declaration is necessary. Anatula Sudhakar, 2008 Supreme Court, 2033. Now a three-judge bench of the Supreme Court in Rahul's case is also important. You please note down the citation later. Rahul's case, wherein the Supreme Court has given certain guidelines. So when we are dealing with this preventive relief, I invite your attention to sections 37 and 38 of the Specific Relief Act in particular. Section 36 is a general section dealing with preventive relief. So what are the ingredients of a suit for perpetual injunction? Assertion that the plaintiff is in lawful possession. Assertion that the plaintiff is in lawful possession. That is a legal right of the possession to continue in possession. There is a corresponding duty to the defendant to not to dispossess without following procedure established by law. Actual overt act, that the defendant actually threatened or tried to dispossess. These are the pleadings generally in a suit for perpetual injunction. Section 40 deals with damages in lieu of or in addition to injunction. Section 41 says, list out cases when injunction is refused. You can read the list. It is only supposing somebody wants to contest for elections, you cannot grant an injunction restraining him. Like such, some instances are given in section 41 as to when perpetual injunction suits cannot be entertained. While dealing with specific performance, one more contention would come before us. Non-payment of consideration. Sometimes even in sale deeds also the same question comes. If without paying consideration, a plea of payment of consideration is taken, it's a false plea. When the plaintiff comes to court taking a false plea, he will be non-suited. But you must be careful. Some Supreme Court decision said, mere false plea is not always sufficient. It's a plea which causes prejudice to the defendant is a real false plea. Then if in a sale deed, a part of sale consideration is not paid, but the sale deed is registered with the confidence that the balance sale consideration will be paid later. The sale deed also recites that only this part is paid, the balance will be paid within 1 year or so. But the balance is not paid. Whether the sale deed is valid or not is the question. What is your opinion? Youngsters, are you following? Am I able to reach the last bench? Yes. It is valid. True. The only remedy for the vendor is to sue for the balance of sale consideration. Recovery of balance of sale consideration, and he can claim, please bear in mind, he can claim a charge on the property. Nowadays we are not claiming these charge reliefs. We have forgotten that law. What is the advantage? For mere recovery, the limitation is 3 years. If you claim charge, the limitation is 12 years. What is the other advantage? he cannot alienate the property. You need not seek any injunction not to alienate during the pendency of the suit. There is a charge decree you will get, and then if the consideration is not paid, you can bring a EP, bring out an EP and bring the property to sale and recover the balance of sale consideration. Supposing not only a part of sale consideration but entire sale consideration is not paid, still the document is valid? Yes, provided the contention is the contract is not at all supported by consideration. A contract without consideration is void. If the establishment of the case goes to that extent, then the document is void. Otherwise, the only remedy is to sue for balance of sale consideration. Vidyadhar versus Manik Rao, AR 1999 Supreme Court 1441 is a landmark judgment. There are number of later decisions. In my view, they are decided on facts of those cases. No law is laid down. Non-payment of entire consideration also, only remedy is to sue for consideration. Unless the plaintiff is able to prove to the extent that it is a contract not at all supported by consideration, a contract without consideration is void under law. So you have to carefully draft the plaint. That is why when a party comes to you, at the foundation level itself, when you are drafting a notice, you must go through the law, keeping in mind what the Supreme Court said, what is the settled legal position, and then make a foundation. Otherwise, you will be doing injustice to a party. Once a document, a contract is fulfilled and a registered document is registered, then there is no unilateral cancellation. You must go to court if you want to question the document. No unilateral cancellation. You cannot go to registrar's office and register a cancellation deed. Parties must mutually execute a cancellation deed. One party cannot go and cancel the registered document. V. Venkata Narasimhamurthy's case, V. Venkata Narasimhamurthy, it is rendered on 15th of November 2024. Please note down the citation. I am not note down the names of the parties. V. Venkata Narasimhamurthy versus Perla Yellayamma, PERLA, Perla Yellayamma, 15th November 24. It's a decision of Andhra Pradesh High Court referring to number of judgments of the Supreme Court. And the Supreme Court decision is AIR 2003 Supreme Court 2418. AIR 2003 Supreme Court 2418. But this cancellation can now be sought by a senior citizen by going before the revenue authorities. There is a new enactment whereby, supposing the father expecting this son to take care of him executes a gift deed in favor of the son neglects the father, then he can go to the revenue authorities and ask the sale deed to be set aside without going to the registrar's office. The tribunal under the said act is competent to set aside the sale deed if the facts are established. Then declarations. One of the senior members sitting here said one of the reliefs which the court can grant under the Specific Relief Act is declarations. Question is, when declaration of a document shall be sought, when cancellation shall be sought. When declaration, when cancellation. Any idea? Yes, sir. Yes. So where the executant of the deed wants the document to be annulled, he must seek cancellation. Where a executant wants the document to be cancelled, he must seek cancellation. If a non-executant seeks an annulment of the deed, he must seek declaration. That what kind of declaration he will seek? The document is non-est, it is illegal, not binding, not valid. This is how, depending upon the facts of the case, the prayer will be drafted. When executant of deed wants it to be annulled, he seeks cancellation. If a non-executant wants a document to be annulled, he seeks a declaration. Shruti Singh's case, AR 2010 Supreme Court 2807. AR 2010 Supreme Court 2807. Coming to cancellation of instruments, just I invite your attention to section 31 of the Specific Relief Act, which empowers the court to cancel a document. There are instances when we read the commentaries, even partial cancellation was also done. See, in good olden days, A is the owner of the property, but B, falsely claiming to be the owner of the property, sells away the property to C. C will not get any title because the settled law is, the legal maxim is, no one can convey a better title than what he actually possesses. B has admittedly no title, so C will not get any title. So in good olden days, A, the real owner, used to ignore these documents. These are ab initio void, they do not serve the purpose, they are not worth the paper on which they are written. But now what is happening because of the decline of the values? What is happening? They are taking this fraudulent deed to a bank and mortgaging. They are executing further sale deeds one after the other. These are creating complexities. When an EC is taken, this document is reflecting in the encumbrance certificate. So in such situations nowadays, even such useless documents also, it is not safe to allow them to be there. Therefore cancellations are being sought on the ground of forgery, on the ground it is void, sometimes it is voidable. A minor's property is sold before attaining the 21 years of age. Within 3 years of attaining majority, he comes to court and says, it is voidable at my option, it is my share is sold. Supposing it is his exclusive property, the document is ab initio void, the court of guardians without permission such a property of a minor cannot be sold. So what is important is, when you are drafting a plaint for adjudging a document to be void or voidable, you must also seek a prayer and ask the court to order such invalid document to be delivered to you. Please bear in mind, this prayer is generally absent. So actual injury is not necessary. See, if a void document is there, what is the injury? There is only an apprehension of injury. Even then section 31 says the suit is maintainable. Another thing, while suing for specific performance, while claiming for alternative relief, of late one important omission is being noticed. See, A entered into an agreement of sale with B. A is the purchaser, B is the seller. Now sale deed is to be executed. Part of consideration or the entire consideration is paid, whatever the case may be. Whether the B is not coming forward to execute the sale deed in spite of oral and written demands, A brings a suit for specific performance. He claims an alternative relief that if the court comes to the conclusion that the main relief cannot be granted, the suit may be decreed for the consideration already paid and received by the defendant. That is the only prayer being sought. But again, charge is not being claimed. Again, charge is not being claimed. In such a suit also, charge can be claimed. Charge is the advantage I already mentioned when charge is claimed is that the limitation is 12 years and the recovery of the money due, it is made sure, because the property which is sought to be sold becomes the charge property. I don't know what is the time, how much time is left for me. Another conflicting view which must be clarified by the Supreme Court in my humble view is, when you are seeking declarations of documents which are registered, one view is that the period of limitation is 3 years. Period of limitation is 3 years. Because Limitation Act says for any declaration the limitation is 3 years. Recently also in 2025 the Supreme Court reiterated that. So that is why when we are seeking a declaration that a document is to be cancelled or to be declared null and void, you have to be very careful in drafting the plaint. You should not seek a bare declaration or bare cancellation. You must seek a consequential relief of perpetual injunction or recovery of possession. Then Article 65 of the Limitation Act would apply. The limitation is 12 years. So these are the aspects which you will understand if you are a practitioner in the trial court. That is the advantage. Am I clear regarding limitation? If you simply seek a declaration, the Supreme Court said the limitation is 3 years. And sometimes you may not know about the registration of the document also. You may come to know after 3 years. The other side may say registration is public notice. There is a presumption of notice because it is a public document, registered document. Then there will be a lot of problem to get over the plea of limitation, bar of limitation. That's the reason why in such suits for abundant caution, some consequential relief without mere declaration must be sought. If that is the case, then the limitation, the bar of limitation would not apply. The bar of limitation would not apply. Please see Shanti Devi case versus Jagan Devi, 2025 INSC 1105. 2025 INSC 1105. then what remains is only two aspects: rectification and rescission of contracts. Rescission of contracts, please go through section 27 of the Act. Rectification, section 26. Survey number is wrongly mentioned, extent is wrongly mentioned, boundaries are correct. Extent is correctly mentioned, one boundary is wrongly mentioned. Rectification may be necessary. So rectification is a relief which a party can be claimed. Supposing survey number is wrongly mentioned, entire boundaries are correct, extent is correct, the executant is not coming forward to execute a rectification deed. Then a suit can be filed asking him to come forward to execute a rectification deed. Section 26. A party or a representative in interest can file this suit. What is rescission of a contract? Cancellation, rescinding a contract. A party wants a contract to be rescinded, the other party is not willing, then he may come to court to judge that the contract is rescinded by me. I refuse to perform the contract. This is possible in two occasions, on two grounds, rescission. One is the document is voidable at his option. The other is the contract is terminable at his option. Very rarely, this rescission is also being granted when the contract is unlawful. This is all about specific performance. If you have got any one or two doubts, we try to clarify. For a beginners, this specific relief act is very, very important because it will not be taught in the law colleges. This act will not be taught in the law colleges. But most of the suits, civil suits, come under the specific relief act for specific performance. In the absence of specific performance, under the contract act for damages. There is no time left, but I'll only tell you one thing about civil revisions. Civil miscellaneous appeals, they are provided under Order 43 of Civil Procedure Code. Regular appeals 41. Civil miscellaneous appeals 43. As I already mentioned, appeal, whether it is a miscellaneous appeal or a regular appeal, appeal is a statutory right. So the orders against which miscellaneous appeals are allowed, they are enumerated in 43, Order 43 of CPC. If an order is not found in Order 43, no CMA lies. Against final judgments, regular appeals. Certain orders which are not final, CMAs. Very rarely, in certain final orders also, appeals would lie. Supposing a stamp duty collector passes an order on the nature of transaction and the stamp duty leviable, maybe a CMA is allowed. That's like a regular appeal, but it will be numbered as a CMA. These are broadly civil miscellaneous appeals. What are civil revisions? మీ దగ్గర ఎవరి దగ్గర సిపిసి ఉందా? Sir, please give it to an youngster. Pass on to an youngster and let him or her read it. Who is helping us? Please read for the benefit of all of us. Section 115. This is very, very important, and that is why I want you to. Okay, I'll read it. You have no mic, amma. Andarki venpaddu nenu chaduvutanu kurchondi. The High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto, and if such subordinate court appears to have exercised jurisdiction not vested in it by law, to have failed to exercise jurisdiction vested, or to have acted in the exercise of its jurisdiction illegally with material irregularity. 3 situations are given. If the trial court order is found to be not valid under these 3 situations, and when no appeal is provided, then a revision would lie to High Court. So supposing a petition to recall a witness was dismissed, a petition to reopen evidence is dismissed. Earlier, civil revisions used to be filed under section 115 CPC. But by way of amendment, a proviso was added. What is that proviso? Provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in the course of a suit or other proceeding, except where the order, if it had been made in favor of a party applying for revision, would have finally disposed of the suit or other proceeding. So if the order which is passed in a pending proceeding has the effect of disposing of the whole suit or proceeding, then only a revision under 115 would lie. That is the change brought about. So therefore, all revisions against orders passed in a suit or pending suit or proceeding are completely curtailed. No revisions would lie under section 115 CPC. Then what happened? Parties started filing revisions under Article 227 of the Constitution of India. Started filing revisions under Article 227 of the Constitution of India, by virtue of which the High Court is having a power of superintendence over the subordinate courts. Power of superintendence over the subordinate courts. Then a issue arose. When a power is curtailed by the legislature, specifically by bringing out an amendment to section 115, by adding a proviso, then is it permissible to circumvent such a provision of law and then again file revisions before the High Court under Article 227? This is the question. Then, in Surya Devaraya's case, the Supreme Court considered all these objections and held that such revisions are maintainable, and the High Court can, under the power of superintendence, deal with such revisions and correct the errors of the trial court. That Surya Devaraya's case is AR 2003 Supreme Court 3044. So revisions instead of under 115 are now maintainable under Article 227. But in this decision, the Supreme Court, while referring to 227, also said such revisions are maintainable under 226 also, which is the general power of the High Court to issue writs. Then the matter came up for clarification in Radhesham's case. In Radhesham's case, 2015 Supreme Court 3269. In this it is clarified such revisions are only maintainable under 227 but not under 226. So revisions are maintainable. Supposing a document is compulsorily attestable, there are only 4 compulsorily attestable documents: mortgage, gift, will and a bond. Supposing the plaintiff for one reason or the other is unable to bring the sole attesting witness for examination on a given date, the evidence is closed. Then he files a reopened petition and a petition to permit the attestor to be examined. Those petitions are dismissed. It's a vitally important aspect so far as the plaintiff is concerned. If that witness who is an attestor to a compulsorily attestable document is not examined, the document remains not proved. So therefore there may be such instances. Therefore the Supreme Court said revisions are entertainable under Article 227. That's all what I wanted to share with you. I thank all of you for the patient hearing. Yes, sir? Yeah, any questions? See, when you are students, what is the difference between a ranker and a non-ranker? మీరు కష్టపడతారు, వాళ్ళు కష్టపడతారు. ఒకప్పుడు మీరు వాళ్ళకన్నా బాగా చదువుతారు, ఎక్కువ కాలం చదువుతారు, కానీ వాళ్ళకి ఫస్ట్ ర్యాంక్స్ వస్తాయి, మనకు రావు. వాట్ మేక్స్ ది డిఫరెన్స్? Discipline. Those persons rise before the sun rises. They have every day extra 1 or 2 hours. Immediately after going home from the college, what has been taught, they make a notes. ఏ రోజు పాఠం ఆ రోజు చదువుకుంటారు. That's the only difference. That's the only difference. You do it and tell me if you are not in the first 5. This is the secret of success. Because, see, as I said, if you are exhorting something, you must be in a position to exhort. Otherwise, you should not just mere give lectures. So what is important? Practice before you preach. So what I suggest to you is, from today onwards, rise before the sun rises. Now, what is universally accepted? Meditation. Do meditation, whatever. Sit simply closing your eyes for some time. Now the new method of meditation is even, you need not even close your eyes. See, there is one ashram or a hill. 2 disciples joined the ashram. They are smokers. They are in the early days, they cannot give up so easily. So one person said, giving up smoking is so easy that I have given up 100 times. That is the difficulty in giving up smoking. You give up, again you smoke. Again you give up. So 100 times you give up, but still you are smoking. So these 2 persons were smoking. So one person went to the master and said, "Can I smoke while meditating?" The head of the ashram said, "No, you cannot smoke while meditating." Then he was disappointed. He found the other person smoking in the ashram. He asked, how come you are smoking? The master did not permit. What did you ask? I said, "Can I smoke while meditating?" Fool, I asked, while smoking, can I meditate? Master said, yes. So meditation can be done at any time. While smoking also you can meditate. So that is how the art of putting a question and getting an answer favorable to you. So this is what is important. How these things come in life, these experiences come in life, reading. You must be a voracious reader. Then only you can articulate your thoughts. If you are putting a point before a judge, the judge says, no, I don't want to hear that point. If you are a good articulative technique with you, you will present the same subject in different words and carry forward your point to the judge. Sometimes it may click. So I suggest to you that all students rise before the sun rises, have a disciplined life, and every day minimum 2 hours general reading. Read. Yes, now open for questions very quickly. I wanted to go away at 4 o'clock. Somebody is raising a hand or relaxing? Thank you so much.
ఈ పూట స్పెసిఫిక్ రిలీఫ్ యాక్ట్, సివిల్ రివిజన్స్ పిటిషన్స్, సిఎంఎస్ మీద మనకి జస్టిస్ సీతారామూర్తి గారు, ఆయన ఫార్మర్ హైకోర్టు జడ్జి, అదే రకంగా మానవ హక్కుల కమిషన్ ఫార్మర్ కమిషన్గా పనిచేశారు. మరి ఈరోజు ముఖ్యంగా ఆయన మా ఉమ్మడి తూర్పుగోదావరి జిల్లా కాకినాడకి చెందినవారు. మరి ఇంతసేపు మన ఆల్ ఇండియా లాయర్స్ యూనియన్, అదే రకంగా విజ్ఞాన్ యూనివర్సిటీ అడ్వకేట్స్ ఓరియంటేషన్ ట్రైనింగ్ ప్రోగ్రాంలో భాగంగా ఈరోజు క్లాస్ బోధించినందుకు ఆయనకి ఆంధ్రప్రదేశ్ ఐలు కమిటీ తరఫున ఆయనకి ధన్యవాదాలు తెలియజేస్తూ, ఆయనకి ఐలు సీనియర్ నాయకులు ఆలూరు సుధాకర్ గారిని వచ్చి బుక్ ప్రజెంటేషన్ చేయవలసింది కోరుతున్నాం.
ఇందులో 10 minutes టీ బ్రేక్ ఉంటుంది. స్నాక్స్ అన్న టీ ఆఫర్ చేశారు. తీసుకొని వెంటనే 10 minutesలో ఇక్కడికి రావాలి. థ్యాంక్ యూ.
అరే ఆ వైర్ మాత్రం జాగ్రత్త ఇంకో 15 minutes కూడా తెచ్చాను ఇదేం ప్రాబ్లం లేదు, ఇది ఒక్కటే ఇస్తే సరిపోతుంది. నేను ఇది ఇస్తే సరిపోతుంది. స్మార్ట్ బోర్డు పడేసి ఎన్ని రోజులు కార్తీక్ ఒకవేళ నేను వెళ్ళిపోతే తెలుసు అవి ఆపేసి స్మార్ట్ డౌన్ సైడ్ తెలుసు. నెక్స్ట్ ఆయన అంతా అయిపోయింది. మనతో కోఆర్డినేట్ అవ్వదు. అరే కార్తిక్ కార్తిక్ అన్నతో మాట్లాడు ఒకసారి. అన్న మనతో ఏం చేస్తున్నాను మ్యాథ్స్ అయిపోయింది. ఏ వర్షన్స్ ఇవి 11 11 Pro
వదిలేస్తే ఆ 6 16 దాకా పోతాయి. ఎందుకు నానే రాసావే నిద్రపోయినా
కొన్ని బిట్లు తక్కువైంది రెండో మూడు అందుకే సార్ పక్కన అమ్మాయి కూర్చోబెట్టుకున్నారు. ఆ కారం మీరు తీసుకురా
పొద్దున్న టైం పెట్టి నీకు ఎందుకు
ఫోన్లో మీకు జ్వరం వచ్చింది ఎందుకు సార్ అంటే
మిత్రులు ప్లీజ్ అందరు అసెంబ్లీ కావాల్సిందిగా కోరుతున్నాం. సెషన్ హలో చెక్ హలో ప్లీజ్ అందరు అసెంబ్లీ కావాల్సిందిగా కోరుతున్నాం. టైము ఈరోజు కొంచెం అడ్జస్ట్మెంట్ జరగాలి, ఎందుకంటే మార్నింగ్ లేట్ అయింది కాబట్టి మీరు అందరు రావడం మార్నింగ్ బ్రేక్ఫాస్ట్ దాంట్లో, కాబట్టి మన షెడ్యూల్ ఇంకా వెనక నడుస్తూ ఉంది. కాబట్టి అందరూ తప్పనిసరిగా టైం పంక్చువాలిటీ పాటించి వితిన్ 5 or 10 minutes ఈ టీ బ్రేక్ బయట ఉన్నటువంటి వాళ్ళందరినీ లోపల రమ్మని చెప్పండి. సార్ రండి, పాట పాడతారా?